What if I told you that America's gun laws are changing right now, not in Congress, not in public debates, not on your evening news, but quietly, inside courtrooms, where almost no one is paying attention? In the last few years, more than 70 major gun-related rulings have reshaped how the Second Amendment is interpreted, and most Americans never heard a word about it. No protests, no headlines, no national conversation, just silent rewrites of your rights. While the media is busy chasing outrage cycles, a deeper transformation is unfolding, one that could redefine what it means to own, buy, and use a firearm in this country. These changes don't arrive with sirens. They arrive as footnotes, filings, and routine court motions. But their impact is permanent. By the end of this video, you'll understand how 10 invisible shifts are quietly rewriting America's gun laws, and why, whether you support or oppose them, being unaware is the most dangerous position of all. For most of American history, gun laws were shaped in public, through elections, debates, and votes in Congress or state legislatures. You could see change coming. You could argue against it. You could support it. Today, that process has quietly shifted. The most powerful changes to gun law are no longer coming from lawmakers. They are coming from judges. In courtrooms across the country, especially in federal appeals courts, single rulings are redefining what the Second Amendment actually means in daily life. A case filed in one state can ripple outward, influencing how other courts interpret the same right. No bill is passed, no president signs anything, yet the rules change anyway. This is how a background check system can be weakened, strengthened, paused, or revived without a single vote. It's how the definition of an arm evolves. It's how keeping and bearing become legal concepts instead of plain English. These decisions are wrapped in dense language and buried in legal databases, but they shape reality. When a court decides that a law burdens a right, or that a regulation fails historical tradition, that phrase becomes the new standard. From that moment forward, every similar law in every similar state is on borrowed time. What once required a national debate now happens through a PDF uploaded at midnight. This isn't slow change, it's silent change. And silence is powerful, because people don't resist what they never see. Whether these rulings expand gun rights or restrict them, the shift itself is the story. The center of power has moved. If you're waiting for Congress to tell you when gun laws change, you'll always be late. The real battlefield is now judicial, not legislative. And most Americans don't even know the war has moved. If this is the first time you've heard that courts are now rewriting the rules of gun ownership, like this video, because awareness is your first defense. Subscribe so you don't miss the next shift before it becomes permanent. For decades, the federal government tried to appear neutral in the gun debate, enforcing existing laws while letting states and courts fight it out. That era is ending. Today, Washington is no longer just an observer. It is an active player. The Department of Justice is now stepping directly into major gun cases, filing briefs, requesting argument time, and openly declaring how the Second Amendment should be interpreted. That may sound routine, but historically, it is anything but. In the past, federal lawyers rarely aligned themselves with individual gun owners against state laws. Now, the government is no longer pretending to stand in the middle. It is choosing a direction and using the full weight of federal authority to influence how courts rule. This matters because courts listen when the United States speaks. A DOJ filing is not just another opinion. It signals what the federal government believes the Constitution demands. Judges know that these arguments may shape future Supreme Court positions. When federal attorneys say a law implicates the plain text of the Second Amendment, that language becomes a legal compass. It frames the issue before the first question is even asked in court. In effect, the government is no longer waiting for rulings. It is helping write them. This shift changes the balance of power. States once acted as laboratories of regulation, testing how far restrictions could go. Now, those experiments face a unified national voice, arguing that certain lines cannot be crossed. Whether that voice is defending gun rights or limiting them, the impact is the same. The battlefield is no longer 50 separate states. It is becoming one national argument over the meaning of a single sentence in the Constitution. When the federal government picks a side, the debate stops being theoretical. It becomes structural. Courtrooms turn into arenas where national policy is forged without legislation. The Second Amendment is no longer shaped only by voters or lawmakers. It is being sculpted by legal strategy, one filing at a time. For generations, most Americans assumed the word arms in the Second Amendment meant firearms. Simple, fixed objects you could point to and define. But in modern courts, that word is no longer treated as static. It is being unpacked, expanded, and reinterpreted in ways that reach far beyond the gun itself. Judges are now confronting a basic reality. A firearm without ammunition is a paperweight. A right to keep and bear something you cannot use is not a meaningful right at all. That logic is quietly reshaping how the Constitution is read. Ammunition, magazines, components, and even the process of acquiring these items are being pulled into the constitutional orbit. In other words, arms is no longer just the object in your hands. It's the entire ecosystem that makes that object functional. This shift matters because modern regulation often avoids banning firearms outright. Instead, it regulates everything around them. It slows purchases, it limits supply. It imposes layers of approval on accessories. On paper, the gun remains legal. In practice, the right becomes harder to exercise. Courts are now being asked whether those surrounding controls are effectively the same as banning the arm itself. If a state makes ammunition scarce, expensive, or delayed, is it infringing the arm? If it blocks common components, does it undermine the right? By forcing courts to answer these questions, the meaning of arms is becoming dynamic. It now reflects how rights operate in the real world, not just in theory. The Constitution is being interpreted in light of modern systems, modern logistics, and modern barriers. This doesn't just affect gun owners, it sets a precedent for how rights adapt to technology. A right that exists only in theory is no right at all. As courts recognize this, the Second Amendment is shifting from a narrow, object-based idea to a functional one. Arms is no longer a thing, it is becoming a process. The Second Amendment never uses the word buy. It speaks of the right to keep and bear arms. For years, lawmakers built entire regulatory systems around that silence, arguing that the government could heavily control how people obtain firearms and ammunition as long as possession itself remained technically legal. But courts are now confronting a simple truth. You cannot keep what you cannot acquire. A right that begins only after a successful purchase is not a complete right. It is a permission slip issued by the state. This realization is moving to the center of modern Second Amendment law. Judges are asking whether barriers to purchase, delays, denials, complex verification systems, or repeated approvals are merely administrative, or whether they function as constitutional obstacles. If the government can slow acquisition indefinitely, or make it so complex that ordinary people give up, then the right exists only on paper. In that light, the act of acquisition becomes the gateway to the entire amendment. This reframing changes the conversation. Instead of asking whether a person may possess a firearm, courts are increasingly asked whether the state may stand between the citizen and the ability to obtain one in the first place. The focus shifts from what happens after ownership to what happens before it. A waiting period becomes more than a pause. A background system becomes more than a screen. Each step is evaluated as part of the constitutional burden. Historically, many rights include an implicit right to obtain what is protected. Free speech assumes access to a printing press. Religious liberty assumes access to a place of worship. The emerging view treats the Second Amendment the same way. If the right exists, then the path to exercising it must also exist in a meaningful form. This doesn't eliminate regulation, but it forces every restriction to justify itself against the core question. Does this rule merely manage access, or does it quietly prevent it? For much of the 20th century, the fiercest battles over gun policy were fought at the federal level. National bans, sweeping regulations, and headline-grabbing legislation defined the conversation. Today, that center of gravity has shifted. The most consequential fights are now unfolding in the states. California, New York, New Jersey, Hawaii, Illinois. These places have become legal laboratories where the future of the Second Amendment is being tested in real time. Each restrictive statute passed by a state becomes a potential constitutional experiment. Each lawsuit becomes a probe into how far regulation can go before it becomes infringement. This matters because state laws are easier to challenge and easier to fracture. A single ruling in one circuit can invalidate an entire regulatory framework. When a state loses, the loss doesn't stay local. Other states with similar laws suddenly find themselves standing on unstable ground. What begins as a regional dispute becomes a national tremor. Courts compare statutes across borders, searching for patterns. A law struck down in one jurisdiction becomes evidence against its twin in another. States are also more willing to push boundaries. Unlike Congress, which must navigate national politics, state legislatures often move faster and more aggressively. That creates sharper legal conflicts. The clearer the overreach, the easier it is for courts to define a constitutional line. In this way, state laws are not just rules, they are test cases. This dynamic creates a paradox. States are trying to assert control, but in doing so, they are supplying the very cases that reshape national doctrine. Each bold experiment invites judicial review. Each defeat strengthens precedent. The battlefield is no longer Washington. It is 50 separate arenas feeding one constitutional narrative. The Second Amendment is being refined not by sweeping national acts, but by a mosaic of state confrontations that together form the future map of gun rights in America. Every society has an invisible boundary that defines what is considered normal, acceptable, or unthinkable. Political theorists call it the Overton window. What falls inside that window feels reasonable. What sits outside it sounds extreme. For decades, much of the conversation around gun rights existed on the defensive, focused on preserving what remained rather than expanding what was possible. But something subtle is happening in courtrooms that most people never see. The window itself is shifting. When a judge writes that ammunition is part of the constitutional definition of arms, an idea that once sounded radical becomes legally ordinary. When an appellate court treats the ability to acquire a firearm as part of the protected right, that concept moves from fringe argument to formal doctrine. Each ruling doesn't just resolve a dispute, it recalibrates what future courts consider normal. Arguments that once drew skepticism begin to sound routine. Language that once seemed bold becomes boilerplate. This process is quiet, but powerful. Cultural change usually follows legal change, not the other way around. Long before society adjusts its expectations, courts redefine the boundaries. What today sounds controversial becomes tomorrow's starting point. Lawyers cite yesterday's extreme idea as settled law. Judges reference it without explanation. Over time, the center moves. This is how entire legal landscapes transform without public drama. There is no announcement that the window has shifted, no banner headline declaring a new normal. It happens through repetition, through citations, through phrases embedded in opinions that future judges inherit. By the time the public notices, the ground has already moved beneath them. The Second Amendment debate is entering this phase. What once required justification is beginning to require rebuttal. The burden subtly changes sides. Instead of asking why a right should be broad, courts increasingly ask why it should be narrow. That inversion is not loud. It is procedural, but it is decisive. Because once the Overton window moves, the future arguments are no longer about whether change is possible. They are about how far it will go. Major constitutional change rarely arrives in a single thunderclap. It comes in pieces, small rulings, narrow holdings, carefully worded opinions that seem modest in isolation. But those pieces accumulate. Each one becomes a brick in a legal structure that did not exist before. In the world of constitutional law, this is how revolutions actually happen, quietly, gradually, and almost invisibly to the public. A single court decision might only address ammunition. Another might focus on waiting periods. Another on licensing standards. None of these cases alone appears to rewrite the Second Amendment. But together, they create a framework. Courts begin to recognize patterns. They adopt shared language. They establish principles that future judges treat as given. Over time, these fragments form a coherent doctrine that defines what the right truly protects and what government may not do. This method is strategic by nature. Large sweeping rulings invite backlash and instability. Incremental change, by contrast, feels technical. It looks like routine legal housekeeping, yet every time a court clarifies that a regulation burdens a core right, it sets a reference point. Every time a judge explains that a restriction must align with historical tradition, that explanation becomes a measuring stick for the next case. The law learns from itself. This is why seemingly small victories matter. They don't just solve individual disputes. They teach courts how to think. They shape the questions future judges will ask before they even reach a conclusion. Once a principle is embedded, it rarely disappears. It gets cited, it gets refined, it gets expanded. What emerges is not chaos, but architecture. A structure built from precedent rather than proclamations, from footnotes rather than speeches, from narrow holdings rather than sweeping declarations. By the time the public realizes that the landscape has changed, the framework is already in place. The debate no longer starts at zero. It starts on a new foundation that did not exist a decade earlier. Most people assume that if something truly important is happening, they will hear about it. A banner will flash, a headline will scroll, an anchor will interrupt programming. That assumption no longer holds. The most significant changes to gun law are unfolding in legal briefs, appellate dockets, and court calendars, places the modern news cycle rarely visits. These developments lack spectacle. There is no rally, no bill signing, no floor vote, just a quiet order, a procedural motion, a paragraph in an opinion. And because they don't fit the rhythm of breaking news, they often pass unnoticed. This silence creates a widening gap between reality and public perception. People continue to debate yesterday's framework while today's rules are being rewritten. By the time a ruling filters into mainstream awareness, it is already settled law. The conversation arrives late, after the consequences are locked in. What looks like sudden change is usually the final step in a process that began years earlier, unseen. The absence of coverage doesn't mean nothing is happening. It means the change is technical, and technical stories don't travel well in an attention economy built on conflict and speed. Explaining how a circuit court reinterprets historical tradition requires patience. It doesn't fit into a 30-second clip, so it disappears. This invisibility has power. When people don't know a shift is occurring, they don't organize around it. They don't ask questions. They don't pressure representatives. The legal system moves without friction. Courts are free to shape doctrine while the public remains anchored to outdated assumptions. That gap grows with every unreported decision. In earlier eras, major legal changes were paired with public drama. Today, they often emerge fully formed, long after the debate that might have influenced them has faded. Awareness trails reality. And in a system where precedent governs the future, arriving late means inheriting outcomes you never had a chance to contest. Elections feel decisive. Administrations rise and fall. Policies reverse. But in the legal world, time moves differently. A court decision does not expire when a president leaves office. It does not reset after an election. Once a principle becomes precedent, it settles into the foundation of the system. Future judges inherit it. Lawyers build arguments on top of it. Legislatures must work around it. In practice, a single appellate ruling can shape decades of law long after the political moment that produced it has vanished. This is why the current wave of litigation matters more than any single news cycle. Political power is temporary. Judicial doctrine is durable. A president may appoint officials for 4 or 8 years, but a court's interpretation of the Constitution can define an era. Even when courts later adjust course, they do so by referencing what came before. The past never disappears. It becomes part of the conversation forever. Gun policy often feels cyclical. One administration tightens, another loosens. But beneath that surface rhythm, precedent accumulates. Each case adds a layer. Each ruling narrows or expands what future lawmakers may attempt. Over time, the boundaries harden. What once seemed politically possible becomes legally impossible. What once seemed unreachable becomes routine. This is the quiet power of the judiciary. It converts temporary strategy into lasting structure. A regulation passed today can be repealed tomorrow. A court's interpretation, by contrast, becomes the lens through which every future regulation is judged. That lens persists even when the political landscape changes. Understanding this reveals why legal battles attract such intensity. They are not about winning the next news cycle. They are about shaping the framework that outlives it. When a court defines the scope of a right, it is not speaking to the present alone. It is instructing the future. Long after today's debates fade, those words remain, guiding how the Constitution is read by people who were not yet born when the case was decided. What looks like chaos on the surface is, in reality, a patient strategy unfolding over years. Constitutional change in America rarely comes from a single dramatic moment. It comes from accumulation, cases chosen carefully, arguments refined, losses studied, wins expanded. Each ruling becomes a stepping stone for the next. This is how durable legal movements operate. They do not chase instant transformation. They shape the terrain so that future outcomes become inevitable. In this long game, timing matters as much as substance. Advocates learn which courts are receptive, which arguments resonate, and which questions judges are willing to answer. They advance claims that can succeed now, not just those they wish would succeed. A narrow victory today can enable a broader one tomorrow. Every decision teaches the system how to think about the right at issue. Over time, the courts internalize those lessons. This approach mirrors how other constitutional shifts took hold in the past. Rights did not appear fully formed. They emerged through stages: first recognition, then protection, then expansion. Each stage required groundwork. Each depended on precedent laid earlier. What seems like a modest clarification can become the hinge on which an entire doctrine turns. The Second Amendment is entering that phase. Instead of asking courts to leap to final conclusions, litigants are building a chain of reasoning. They establish definitions. They connect text to function. They align modern realities with historical principles. The goal is not a single headline-grabbing victory, but a framework so coherent that future courts naturally extend it. From the outside, this can feel slow or fragmented. But in law, momentum is cumulative. Once a principle gains footing, it rarely retreats to zero. It evolves. It expands. It becomes the baseline for the next generation of cases. By the time the public recognizes the destination, the path has already been paved. What is unfolding is not a moment. It is a trajectory. And trajectories, once set, shape everything that follows. All of these shifts lead to one unavoidable truth. The rules that govern your rights are changing whether you are paying attention or not. You may wake up one day and discover that what was once restricted is now protected, or that what you assumed was permanent has quietly disappeared. These changes won't arrive with alarms. They won't ask for your permission. They will already be in effect by the time most people notice. That's the power of precedent. It moves ahead of public awareness. This doesn't require you to take a side. It requires you to stay informed. Rights, of any kind, don't vanish in one dramatic moment. They erode or expand through technical language, narrow rulings, and quiet decisions that feel insignificant until they stack on top of each other. The people who are prepared are the ones who see the shift early, not the ones who react after it's complete. Whether you support stronger gun rights, tighter regulation, or something in between, the worst position is ignorance. You cannot participate in a future you don't understand. The courts are writing that future right now. If this video gave you clarity you didn't have before, like it so others can find it. Subscribe so you're not blindsided by the next ruling that changes everything. And tell me in the comments, did you realize this transformation was already underway?